As the terms are being stipulated for Illinois' gun ban challenge, trial sets for mid-September, you've got a case out of New Jersey where a judge has found the assault weapons ban unconstitutional. It is Illinois in Focus Daily. I'm Greg Bishop, and you can follow along anytime. Just go to America's Talking Network. Like, subscribe, hit that notification bell. Also search for Illinois in Focus wherever you get your podcasts. So yesterday, New Jersey judge issuing a ruling on a challenge to the New Jersey gun ban. And we'll take a look at this here in just a moment, as we had a bit of a freeze here for the live stream. But of course, we record these segments locally so that you can get all of it without interruption and get the podcast. Like, subscribe, hit the notification bell to get the segments each and every morning here with Illinois in Focus Daily. Again, you can follow me anywhere, Bishop on Air. You can also find the social media. Just search for Bishop on Air anywhere. Okay, it says we are reconnected. Live stream is always apt to recognize when it drops briefly and then we come back on. So we are back, and let's talk about the New Jersey gun ban with a judge making a decision yesterday. So go to Firearms Policy Coalition. They handle a lot of these lawsuits that are all across the country. They're even involved in Illinois' gun ban. But this is out of New Jersey. All right, so let's get the summary. Federal law challenging New Jersey's assault weapons ban is unconstitutional under the Second Amendment. You've got a list of plaintiffs there. The defendants being the Attorney General, the State Police Director, acting county prosecutors, and so on. But here we are with some of the latest. So yesterday, an opinion was filed with an order and judgment and also a notice of appeal. So let's go to the opinion here. Pull this up and read along. And here in a bit, for those keeping track of Illinois' gun and magazine ban, we do have some stipulations that Judge Stephen McGlynn has issued for the trial set for September 16th in the Southern District of Illinois Federal Court in East St. Louis. So we'll get to that here in a moment, but I wanted to get to the New Jersey gun ban with a ruling that came out yesterday. So you go through all the lists, and here we are. We'll just kind of skim through this a bit. This is from the New Jersey courts. Before the court are consolidated cases in which two motions for summary judgment and cross motion for summary judgment. Plaintiffs challenge New Jersey's assault firearms law, claiming that aspects of the regulatory scheme are unconstitutional under the Second and 14th Amendment. More specifically, plaintiffs challenge the constitutionality of assault firearms law's prohibition on the possession of so-called assault firearms and a provision within the assault firearms law that regulates the possession of large-capacity ammunition magazines to magazines capable of holding no more than 10. Now, again, you're going to see a lot of similarities here, but still some distinct differences between New Jersey's law that's being challenged that a court said is unconstitutional. That's been appealed, so of course the case continues. But Illinois' law, especially when it comes to the gun ban and the magazine ban. The magazine ban is for banning anything over 15 rounds for a handgun and anything over 10 rounds for a quote-unquote assault rifle. So you got this order. It's 69 pages long, and let's see if we can find some of the resolution here from the judge's order, again, which in New Jersey has been appealed. But scrolling through here to get to the facts and the plaintiffs that there are, but ultimately we want to get to the order and the ruling on the challenge of New Jersey's gun and magazine ban. So scrolling through, getting to some of the particulars and the arguments back and forth. The opinion from the judge laying out all of the arguments, and again, 60 some odd pages here, almost 70 pages. And you can find this again at the Firearms Policy Coalition's website to just search New Jersey, and you'll be able to find this case. But all the way going down, and of course, this is some dense reading. You've heard a lot of the arguments back and forth, commonly, owned firearms and so on. And let's keep going, see what else we've got here. Constitutionality of the LCM amendment under the Second and 14th Amendment, applying Bruin test One looks at first whether large capacity ammunition magazines are entitled to Second Amendment protections under the plain text of the Second Amendment. The courts need not look far to answer this question. The Supreme Court has held the possession of arms also implies to the possession of ammunition. Goes on to say, U.S. v. Miller, this reading has been confirmed by the Third Circuit, which has held that large-capacity ammunition magazines are an arm within the meaning of the Second Amendment. Specifically, the Third Circuit has stated, since magazines feed ammunition into certain guns and ammunition is necessary for such a gun to function as intended, magazines are arms within the meaning of the Second Amendment. While the Third Circuit's decision on this point was made prior to the Supreme Court's decision in Bruin, the court does not read Bruin to disrupt the Third Circuit's reading of the plain text of the Second Amendment. It goes on to talk about some of the other factors here in a similar argument to the leveled against the assault firearms laws AR-15 provision. State defendants argue the large capacity magazines are not in common use today for self-defense and therefore unprotected under the Second Amendment. The state's defendants argue that the evidence before the court shows the civilians acting in self-defense rarely use more than 10 shots and rarely use more than one magazine. Therefore, state defendants argue the magazines holding more than 10 rounds are rarely used for self-defense. The Third Circuit's addressed this question, although less definitively. Goes on to say, applying the now defunct two-step approach under immediate scrutiny, the Third Circuit assumed without deciding the LCMs, large capacity magazines, are typically possessed by law-abiding citizens for lawful purposes. It did, however, observe that millions of magazines are owned, often some come from factory standards with semi-automatic weapons, and are typically possessed by law-abiding citizens for hunting, pest control, and occasionally self-defense. The court agrees with Judge Andrews' review, and what is more, the court believes that by definition, large capacity magazines are commonly owned, given that large capacity ammunition permits some level of large capacity magazine ownership in the state of New Jersey and has done so for more than 30 years. The court moves next to the analysis of the state of New Jersey's jurisdiction, justification rather, for its regulation by examining its reasons for regulating large capacity magazines. Goes on to discuss this even further, and we'll just continue to skim through because we only have so much time in each day. But despite the issuance of detectable magazines, reading through more, and some, the relevant large capacity magazines simply did not exist during the founding era. As a result, the next step is to engage in an analogical inquiry by assessing how and why the regulations burden a law-abiding citizen's right to armed self-defense. The apt historical analogous here, analogs, are other firearms, specifically pistols and a Bowie knife. With respect to pistols, the relevant restrictions provided by the state defendants are largely contemporary. For example, state defendants' experts witness cites 20th century regulations surrounding firearms, more broadly linked to the surge in violence in the United States that occurred between Mexican-American War and Reconstruction. Goes on to talk about other experts that they had. Spitzer details the regulation of semi-automatic weapons in the early mid-19th century. As the Supreme Court noted in Bruin, while history has weighed this analysis, the use of the post-Civil War discussions on the right to keep and bear arms took place 75 years after the ratification of the Second Amendment and does not provide as much insight into original meaning as earlier sources. So again, some interesting things here being raised, and as far as the history, the experts that there were, and more. But continuing on here, it looks like we're getting to the end of the opinion. Let's see. For these reasons, the large capacity amendment is constitutional. The constitutionality of the large capacity magazine amendment under the 5th and 14th Amendments goes on to explain plaintiffs Ellman and Weinberg also bring claims asserting that violations of the Takings Clause in the 5th Amendment. Plaintiffs argue that they suffered damages because of the LCM amendment. Specifically, plaintiffs Ellman and Weinberg argue that their large capacity ammunition magazines have been taken from them without just compensation. The exact issue was already addressed in the Third Circuit in the court's reading of Bruin. Bruin altered the meaning the means and scrutiny analysis of the Second Amendment analysis. And while the Supreme Court vacated the judgment and remanded the matter for reconsideration in light of Bruen, the court does not read anything in the text of Bruen to disrupt the Third Circuit's decision as it relates to the Fifth Amendment analysis. In the same way, the court is bound to follow decisions of the Supreme Court. The court is bound by the decision of the Third Circuit. The LCM amendment is not an unconstitutional taking. The AR-15 provision of the assault firearms law is unconstitutional under Bruen and Heller, as the Colt AR-15 for use of self-defense within the home. In contrast, the LCM amendment is constitutional under these same decisions. The Third Circuit's decision on whether the LCM amendment constitutes an unconstitutional taking and its finding that the LCM amendment does not remains valid since Bruen did not disrupt this holding. An order and judgment follows. Okay, so a lot of stuff there. No question, worth unpacking even more. Again, 70 pages of especially the deep analysis of the large capacity magazines, but the Firearms Policy Coalition highlighting this as well, mostly a victory. Then the order and judgment that is filed. It's a much shorter document here, as you've got the order for summary judgment in this particular case. To the extent it seeks summary judgment in their favor, declaring that a law is unconstitutional, ordered that the motion for summary judgment by plaintiffs, to the extent it seeks summary judgment in their favor, declaring the New York State, New Jersey law unconstitutional, it's ordered that it includes the Colt AR-15 and the motion for summary judgment by plaintiffs is to extend it and seek summary judgment in their favor. It's all these different orders. So this is not going to go away, of course, because it has been appealed. So that's what's happening in New Jersey. Now, Illinois, in particular, has the ban on assault weapons and high-capacity magazines, LCMs, if you want to call them large-capacity magazines. And in that case, you've got the consolidated cases in the Southern District. Those are moving forward. You've got a bench trial that's set for September 15th. And in that bench trial, some stipulations are being made. And this was released on the docket earlier this was it earlier this week or late last week? Judge Stephen McGlynn issuing what is called a joint stipulation regarding expert witnesses and trial procedure. And I'll give you just the quick overview here. I read that this morning, and it essentially says, listen, here are the terms. Here's the people that the plaintiffs are going to have actually testify during that bench trial. Here are the experts that the defendants want to have testify at the trial. There are some individuals who are going to provide expert testimony that aren't going to testify. There can be depositions made here and there, but ultimately all of this, as Judge Stephen McGlynn says, is to reduce the burden and cost of discovery, ensure the party's readiness by the scheduled trial date. Again, that scheduled trial date, September 16th. Like, subscribe, hit that notification bell if you want to stay up to date on that. It goes on to say that it limits the length and the cost of the trial and wants to promote judicial efficiency and the convenience of witnesses, and in furtherance of the goals set forth in the Federal Rule of Civil Procedure 1, the plaintiffs and the undersigned defendants in the above captioned case respectfully submit the stipulations pursuant to Federal Rule of Civil Procedure. September 16th, it's going to be an interesting day. Is McGlynn, the judge in the Southern District of Illinois, going to rule from the bench, or is he going to take everything under advisement and then make a ruling later? And would that ruling mean if he finds the law unconstitutional on final judgment, will there be an injunction to block the law from being enforced? And that goes back up to the Seventh Circuit Court of Appeals, and then from there to the U.S. Supreme Court. But there could be other cases, like we just saw it in New Jersey, could make it to the U.S. Supreme Court beforehand. Things to watch, and that's why you like, subscribe, and hit that notification bell each and every weekday morning here with Illinois in Focus Daily. Appreciate you guys' time and muddling through that 70-page court document with me, but always fascinating to see how they put these things together and all the arguments. All right, follow me anywhere. Bishop on Air, X, Facebook, anywhere. But also like, subscribe, and hit that notification bell for America's Talking Network. It is Illinois in Focus Daily. I'm Greg Bishop. Thank you so much for being with us here with the Center Square and America's Talking Network.